There is a comfortable assumption we tend to make about the legal system. We think the existence of a beautifully drafted, constitutionally sound law ensures that justice exists. In reality, the existence of law and the presence of justice are two separate things. Speaking at the St. Petersburg International Legal Forum, Chief Justice of India, Suryakant, addressed this gap. He argued that law without equality functions as the organized will of the stronger party. Consider a conflict where one side has money, political influence, elite lawyers, and time, while the other side faces poverty, language barriers, and fear. Even a perfectly valid statute can operate as a weapon if access to it remains structurally unequal. The proof of equality lies in whether the weakest person in a society can successfully use those statutes to hold the most powerful person accountable. Legal history often treats the 1215 Magna Carta as the singular origin point for the concept of restraining power. But the Indian subcontinent described this danger much earlier through the concept of Matsyanyaya, the law of the fish. Kautilya's Arthashastra warned that without legal restraint, society becomes a battlefield where the big fish simply swallow the small ones. This anxiety echoes through the Mahabharata, specifically in the humiliation of Draupadi. The royal assembly had authority, rules, and established procedure, yet justice collapsed because the strong controlled the forum, while the vulnerable were forced to plead before a silent, complicit leadership. To counter concentrated authority, early Indian experiments like the Republic of Vaishali relied on collective assemblies and shared decision-making. They built structures based on the fear of a single person's will dictating the law. These traditions show that the modern constitutional fight for equality is the continuation of an ancient effort to replace the law of the fish with the discipline of Dharma and Rajdharma. The Constitution turned these ideas into enforceable language. Articles 14, 15, and 21 act as barriers against arbitrary power, protecting personal dignity. But a massive distance separates these guarantees from everyday experience. On the ground, social gravity frequently pulls harder than the legal text. While constitutional courts hold immense theoretical power to correct these imbalances, for millions of citizens, these institutions remain physically, financially, and linguistically unreachable. This gap between the promised architecture of the law and the friction of the legal experience defines the central crisis of Indian justice. Systemic inequality enters the legal process through three specific doors. The first door is social inequality. Local hierarchies of caste, religion, and gender dictate the state's response. At a local police station, social status often determines who is believed, who is doubted, and who is ignored. The second door is economic. In the courtroom, time favors the wealthy. A corporation can afford to use litigation delays as a strategy, while a poor litigant experiences those same delays as a direct punishment. Beyond lawyer fees, the system drains the vulnerable through the high cost of travel, the loss of daily wages, and endless mountains of documentation. The third door is procedural. The technical vocabulary, complex court procedures, and intimidating police processes act as barriers. Ordinary citizens often find themselves trapped in a maze they cannot navigate. These procedural and economic obstacles fall heaviest on marginalized populations, such as migrant workers. Their legal rights may be clear, but a lack of specific documents, language, and money makes those rights impossible to enforce. Equal access serves as the primary foundation for a legal system. Constitutional guarantees lose their substance the moment they remain physically and financially out of reach for the citizen. The legal system attempts to correct these imbalances through the principle of substantive equality. It recognizes that treating vastly unequal people in the exact same way does not produce a fair outcome. If the state ignores inherited disadvantage, formal sameness only preserves existing hierarchies. Tools like public interest litigation, professional legal aid, and reservations are designed to build a bridge over those disadvantages, allowing the state to actively disrupt the reproduction of power. This principle of selective legality, where rules are strict for the weak but flexible for the strong, follows the same logic on the global stage. International legal structures face a credibility crisis when they aggressively scrutinize nations from the global south, while permitting powerful states to bypass trade rules or human rights narratives. Selective legality, whether in a local police station or a global assembly, turns law back into a tool for the strong. A legal system only succeeds when it prevents power from continuously using the law to protect itself. Achieving this requires structural change. We need massive investment in trial courts and the creation of a professional, heavily funded legal aid system that treats the poor person's case with urgency. We must democratize legal language, enforce strict accountability for police misconduct, and ensure that technology, like digital courts, does not exclude those without internet access or literacy. But the core requirement is a psychological shift. Institutions and society must stop treating inherited privilege as natural superiority and start valuing the time and dignity of every citizen equally. If equality is removed from the foundation, the law remains, but only as organized power and the managed mercy of the strong. That is not the rule of law. That is domination using a legal vocabulary.
For legal clarity and practical solutions, subscribe to Ravi Legal.